I want to end this guardianship. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this very tricky subject of terminating a guardianship once it's in place. Now remember, a guardianship is a court-imposed process in which the court appoints a fiduciary called a guardian to make sure that the care and well-being of the individual is provided for. But the imposition of a guardianship really affects the person's rights who are under guardianship. So often people would like to terminate that guardianship to no longer be under the imposition of a fiduciary guardian or the court's involvement. And how do you do this? It's done by filing a petition to terminate guardianship, or by as simple as an informal letter to the court seeking for the end of that guardianship. The court then triggers a court hearing in which there's an adjudication as to whether the guardianship is necessary. Now, the court, in a recent case, applied the wrong standard. The court used the standard of whether it's in the best interest of the individual who's under guardianship. And the Court of Appeals in that particular case said, no, that's the wrong standard. The standard that needs to be applied is the same standard for the creation of that guardianship, which is clear and convincing evidence of the need for the guardianship. So if somebody's seeking to petition for guardianship, to terminate the guardianship, there's going to be a court hearing, and at that court hearing, it's very similar to what occurred at the beginning petition to establish the guardianship. There has to be a determination, clear and convincing evidence standard of the need for continuing the guardianship. If you have questions about terminating a guardianship or any probate related matter, visit us at theprobatepro.com or call us at 1-833-PROBATE.